In recent years, bureaucracy has become a reign of terror within the United States. Departments, agencies, and administrations have been increasingly used as tools to grab at essential civil liberties. The Amish Farmer case, being one which I covered in depth on this channel, highlights the extent to which administrations, both state and federal, regulate our food industry. And if you missed any part of the Amish Farmer coverage, I will link the playlist to it in the description of this video. But cases like that of the Amish farmer leave many of us asking how. How have administrations and unelected officials attained so much control over the daily lives of private citizens, private farms, and private businesses? The answer lies largely in what is known as the Chevron Deference, a legal doctrine that was the result of a 1984 Supreme Court ruling. This doctrine mandated that judges within federal courts submit or defer to an agency's interpretation of silence or ambiguity within the law. Fortunately, 12 weeks ago, after 40 years of precedent, the Supreme Court of the United States struck down the Chevron Deference as being unconstitutional and, quote, fundamentally misguided. However, 40 years of precedent was enough time for Chevron to leave serious marks on patterns and behaviors within U.S. government. Behaviors that thankfully no longer are hedged by legal precedents, but behaviors that will need to be checked and changed by the demands of a well-educated American public. This video is going to tell you what the Chevron Deference was for 40 years, how the Chevron Deference covertly funneled power to the executive, the presidential branch of our government, and finally, I'm going to suggest what will be required in order to turn what I believe is now simply neutral ground into positive territory. I'm also going to address how this is going to impact cases like that of the Amish farmer in Pennsylvania, whether it will provide relief or not. Now, the Chevron Deference was established in 1984 in a case involving Chevron Oil and the Natural Resource Defense Council. Now, ironically, in light of my last upload on the hidden dangers of climate control policy, the case involved the regulation of emissions out of Chevron oil facilities. The NRDC was enforcing the Clean Air Act of 1977, but that particular act contained fuzzy or ambiguous language with respect to how these emissions were to be regulated. Long story short, that lawsuit resulted in the Chevron Deference and its subsequent legal doctrines. The ruling cited that when a law or statute is ambiguous or silent, federal courts must give deference to a government agency's interpretation of that silence or ambiguity. Now, not only were these federal agencies allowed to interpret, but they were also permitted to create rules around silence and ambiguity within the law. And you're probably already seeing it, but over the years, Chevron has been labeled the Lord Voldemort of administrative law. And while I've never watched the movie, a quick Google search showed me exactly what people meant by this. Chevron became a picture of administrative evil, ultimately funneling power to the executive branch of government that it was never intended to have. And here is exactly how. Now, this is going to be a very simplified look, but if you would like a technical analysis, I'd recommend Epic TV's 1-hour interview with Philip Hamburger. He's an American legal historian and a scholar of constitutional law. But to put it simply, as we all learned in middle school, power within our federal government is divided into 3 branches. The legislative branch is where Congress resides. Elected officials from each state come together to discuss and agree upon laws or rules, the Constitution being the framework in which these new laws or rules are made. The executive branch is where the president resides. The president and his team essentially give a stamp of approval to the laws or rules that come out of the legislative branch. And the judicial branch is where judges and the court system reside. Judges being elected officials who make judgments as to how to apply the law on a case-by-case basis. Now, these 3 branches work together under the authority of the Constitution and the accountability of the American people, who can vote them in or out during various election cycles according to how good or bad of a job that they are doing. But Chevron became ugly because it gave types of legislative and judicial power to administrations within the executive branch. It created this covert system of centralized power at the federal level. 3 branches of federal government still existed outwardly, but the executive branch now had the ability, under the guise of administration, to act as all 3. And in case it's not entirely clear how, here's a quick summary. Where Congress used to hold the somewhat exclusive right to make laws and write rules, under Chevron, federal agencies now had permission to make rules where the law was silent or ambiguous. And as Philip Hamburger cites, silence and ambiguity is not hard to find in any given law. Second, where judges in the court system or the judicial branch are tasked with executing judgment without bias, under Chevron, judges were obligated to defer to federal agencies so long as their interpretation was deemed reasonable. According to SCOTUSblog.com, Chevron has become one of the most important rulings on federal administrative law, cited by federal courts more than 18,000 times since 1984. Now, Chevron not only provided strong legal precedents for bureaucracy within the court system, but according to Philip Hamburger, it actually reshaped behavioral patterns within Congress. To paraphrase Hamburger, Congress has for 4 decades handed off its responsibility of rulemaking and interpretation to various federal agencies. Philip Hamburger goes on to cite that the Chevron doctrine has even profoundly influenced our modern presidential election. Quote, when all of the regulatory power of the federal government is in the hand of agencies under some degree of control or restraint by the White House, then everything turns on a presidential election. Too much turns on it. This is one reason why presidential elections have become warfare. Now, as for how Chevron is going to impact cases like that of the Amish farmer in Pennsylvania, Chevron was a federal ruling, which technically means it has no precedence in state courts, and for this reason, it will not provide any immediate or direct relief for a case like that of the Amish farmer. However, I would suggest that despite being a federal case and a federal precedence, it has tremendous spillover to the state level, and I suggest this based on sitting in a courtroom in Pennsylvania and watching a Commonwealth judge defer to the Department of Agriculture's interpretation of a raw milk permit, which could give us hope that the striking down of Chevron may lend aid against bureaucracy at a state level. Now, this brings us to today. As of June 2024, the Chevron Deference was ruled unconstitutional by the Supreme Court of the USA. Now, this came after 2 private fishing boats in New England challenged regulations out of the National Marine Fisheries Service, regulations that required those private fishing boats to carry and pay for observers. Observers being individuals who would stand on deck and collect data about the fishing boat's catches and monitor for overfishing. Now, these private fishing boats initially lost, as under Chevron's precedence, deference was given to the National Marine Fisheries Service. However, the ruling was appealed and taken to the Supreme Court, where Chevron was struck down as being unconstitutional and fundamentally misguided. But here's what I would submit for conversation. This is not an advancement, but rather a return to neutral ground, from which advancement can be made to either the negative or the positive. And what I mean by this is that I believe that the administrative state, bureaucracy, will be very quick to re-enthrone itself and reestablish its previously asserted power to make rules and influence the judicial system by some alternate means, unless individuals and businesses become proactive in putting legal counterpressure, similar to how those 2 private fishing boats challenged the National Marine Fisheries Service. We will also need to be proactive in awakening Congress to its role to not only write the law, but also to provide constitutional definitions where ambiguity and silence present themselves. Now, that is in my opinion. Give me a thumbs up if you agree, and weigh in with your opinion in the comments section. Would you consider this a major advancement or simply a return to neutral? I will look forward to reading your comments, and if you missed it, watch this video next, where I talk about the dangers of climate control policy to our food system and what you and I can do about it.